Let's start. The main contention raised on behalf of the appellant, the state of Maharashtra, against the sustainability of the judgment of the High Court under appeal by Sri Ashok Desai, its learned counsel, relates to exercise of discretionary power conferred on the High Court under Article 226 of the Constitution for grant of relief of payment of compensation to the writ petitioner within bracket respondent here for his land alleged to have been utilized by officers of the state government in the year 1971-72 for construction of a public road against his wish, refusing to consider the plea of laches or undue delay of 20 years raised on behalf of the state government as a ground entitling the writ petitioner for grant of such discretionary relief. According to him, High Court's power under Article 226 of the Constitution to grant relief to a person by issue of directions, orders, or writs for any other purpose, when was purely discretionary judgment of the High Court by which such relief is granted becomes unsustainable if it is shown that the same has not been founded on sound discretion, that is, on consideration of recognized judicial principles governing exercise of such discretion, to wit, laches, undue delay, acquiescence, waiver, or the like on the part of the person seeking relief. Further, according to him, when it is well settled that High Court's discretionary power under Article 226 of the Constitution could be exercised to grant relief only to a person whose conduct does not disentitle him. To obtain such discretionary relief, the High Court cannot refuse to take into consideration petitioner's conduct which disentitles him for such relief merely because it is the state against which such relief is sought. When a citizen complains against the state which is interested in protecting his legal rights by filing a petition under Article 226 of the Constitution of infringement of his legal right and seeks exercise of High Court's discretionary power to grant him relief, the need for the High Court to look into the conduct of the citizen disentitling the discretionary relief sought is, if anything, of great public importance, for grant of such relief against the state would result in loss to the state, that is public money. His contention therefore was that impugned judgment by which relief had been granted to the writ petitioner within bracket respondent here, refusing to consider the ground of laches, undue delay of 20 years urged on behalf of the state against grant of such relief, was liable to be interfered with and set aside as that made by the High Court in wrong exercise of its discretionary power under Article 226 of the Constitution. The judgments of the High Court in 191 other writ petitions rendered by following the judgment impugned in this appeal were also liable to be annulled as a consequence. Stop. Thank you. Sri Ashok Desai, in his reply to the submissions made on behalf of the respondent and others who had obtained judgments in their favor from the High Court. Stop. Thank you.